So, hello everyone, I'm Camila, and I'm going to present my FARAC, which is in human rights. It is the case of Stec and others versus the United Kingdom. It is a case about gender discrimination in which the applicants of these applications against the United Kingdom alleged that the social security law of United Kingdom was violating their fundamental rights in the basis of sex. So we are talking about the right of equality. This case is originated into different applications against the United Kingdom of Great Britain and the Northern Ireland lodged with the European Court of the Human Rights under the Article 34 of the Convention for the Protection of Human Rights and Fundamental Freedoms. So first, I'm going to expose the facts, which are going to be explained in a general and individual way because there are in total 5 applicants. And we have to take into account that this case is surrounded or is into the working field. So the first applicant is named Regina Hapel. She was born in 1933 and she lives in Wakefield. The second was named Anna Stec. The third one, Patrick Long. The fourth one, Sybil Spencer. And the fifth applicant was Oliver Kimber. Each, like the applicants, divide into groups, which are the 2 different applications I talked about before. The first, the second, and the third one, the third and the fourth one were represented by J. Sterling, and the fifth applicant was represented by J. Lynch. So, first we're going to talk about Mrs. Heppel, who later on the process, she informed the court that she, for personal reasons, no longer wished to continue with the case. So her representative then just was running the cases of the other applicants. So then we're going to talk about Mr. Stec, who says that on the January 18th of 1989, he injured his back at work and he was unable to continue working. She was awarded a reduced earning allowance, which is a benefit that is part of the social security law of the United Kingdom that available to those who cannot earn as much as they used to because of an accident or an industrial injury or disease in work, to gain kind of the same amount of money that they should be gaining if they never had that accident or that disease. So she received this benefit, and on March 13th of 1993, she reached the age of 60, and as from 31 of March of 1996, her award of reduced earning allowance was replaced by the award of retirement allowance, which are 2 different benefits for 2 different reasons. The retirement allowance is the benefit that is given to people of certain age when they cannot work anymore. The state is obligated to pay like a salary to those people. And as we know, in every country or almost every country, this law of retirement allowance is different for men and women because the age of women of retirement is lower than the one of men. So, the applicant appealed against the decision of the ground of sex discrimination to the Trend of Social Security Appeals Tribunal, which allowed her appeal on the 4th of October of 1996, and the adjudication officer subsequently appealed to the Social Security Commissioner. So the fact here was that the reduced earnings allowance was more beneficial for Mrs. Stec than the retirement allowance. So she was appealing this discrimination to continue gaining the reduced earning allowance, saying that it's unfair that men have like a major, like that women have a lower age in the retirement allowance than men. So that's the first case, which was Mrs. Stec. The second one was Mr. Lon, who in November 11th of 1973, he suffered a work-related injury to his right hand, as a result of which he has to stop working. It is kind of the same case, but here for Mr. Lon was more beneficial the retirement allowance than the reduced earning allowance. So he was appealing for sex discrimination to say that it was unfair that women were retiring in a younger age than men, and that he deserves to have the retirement allowance at the age that women receive it. The third case was Mr. Spencer, who suffered a work-related injury to her neck. Mrs. Spencer, sorry, who suffered a work-related injury to her neck on July 17th of 1966. The case is the same, and every applicant basically appeal the same vulneration to the fundamental right of equality in the basis of sex. So, the issue that I conclude or deduce from this case was if the Article 7 1A of the Council Directive of December 19 of 1978 on the progressive implementation of the principle of equal treatment for men and women in matters of social security permit a member of state to impose unequal age conditions linked to the different pension ages for men and women under its statutory old age pension scheme, violating Article 14 of the Prohibition of Discrimination of the European Convention of Human Rights. So, now that we have the issue, we have 3 rules that we are going to apply later in this case. So, the first rule is the Article 4 of the Council Directive on the progressive implementation of the principle of equal treatment for men and women in matters of social security. So, the Council Directive is like the law that states which are the rules of social security in United Kingdom. And Article 4 says that the principle of equal treatment means that there should be no discrimination whatsoever on ground of sex, either directly or indirectly by reference in particular to material family status, in particular as concerns. So they say that the scope of the schemes and the condition of access, the obligations to contribute and the calculation of contributions, the calculations of benefits, including increases due in respect of a spouse, and for dependents, and the conditions governing the duration and retention of entitlement of benefits. And second, the principle of equal treatment should be without prejudice to the provisions related to the protection of women and the grant of maternity. So here we see that the restriction of discrimination is clear in Article 4, but they never mention anything about age. So Then we have Article 7 of the same Council directive, and it says, this directive should be without prejudice to the right of member states to exclude from its scope the determination of pensionable age for the purpose of granting old age and retirement pensions and the possible consequences, therefore, for their benefits. B. Advantages in respect of old age pensions schemes granted to persons who have brought up children, the acquisition of the benefit entitlements following periods of interruption of employment due to the bringing of children, and C. The granting of old age or invalidity benefit entitlements by virtue of the derived entitlement of a wife. So here we have like the mention of age, and later on we will see why the state fundaments that this determination of the age of or the pensionable age is not violating the Article 14 of the European Convention of Human Rights. Then our next rule is the Article 14 of the European Convention of Human Rights, and this article basically defines what discrimination is and what is the prohibition of discrimination. So it says the enjoyment of the rights and freedoms set forth in this convention should be secured without discrimination on any grounds such as sex, race, color, language, religion, political or other opinions, national or social origin, association with a national minority, property, birth, or other status. So these three rules were the ones that the court applied into this specific case, and now we're going to see the application. In this case, the court decided to base their interpretation of the case and of the rules based in three general principles or like guidelines to analyze the case in a better way. So the first one is that the applicants complain of a different treatment on the basis of sex, which falls within the non-exhaustive list of prohibited grounds of discrimination in the Article 14 of the European Convention of Human Rights. And then the second guideline is that Article 14 does not prohibit a member of a state from treating groups differently in order to correct factual inequalities between them. Indeed, in certain circumstances, a failure to attempt to correct inequality through different treatment may in itself give a rise to a breach of the article. So this is what it is known in doctrine as like a positive discrimination, where to correct some factual inequalities, what the state does is to generate a different treatment to certain groups that have been historically vulnerable to benefit their conditions in certain fields. In this case, we are talking about the work field, and this is the second guideline. And lastly, the third guideline is that a difference of treatment is, however, discriminatory if it has no objective and reasonable justification. In other words, if it does not pursue a legitimate aim of it, or if there's not a reasonable relationship of proportionality between the means employed and the aim. So here we are seeing the concept of proportionality, which is really used, and here what we are going to see is that the arguments to state this difference of treat and the actions that the state took based on this are proportional with the real situation of women pues in this age. So what we are going to see is also like why historically the United Kingdom decided to treat different men and women in the field of pensions. So now we're going to see the application of these three guidelines into the particular case. First of all, we're going to talk about why does this difference come into existence. So in United Kingdom before 1940s, when the convention didn't exist, there was a really big disparity between the conditions of male workers and female workers. Because, as you know, there was a really different treatment. There was a financial inequality. There was a hardship arising out of women's traditional unpaid role, which means that because the labor or the work of women wasn't as valuable as men work, they were unpaid, which also create a lot of situations of vulnerability, not only for women but their families. So, for example, if the convention didn't exist and there was this tradition of not paying women on their work, maybe after war, these women that were the only ones who were bringing money to their homes weren't going to be paid. So their families will be on a state of poverty, and they will be families that were disprotected by the state. And all because of the difference that we see on the basis of sex. So this is the first argument, and they say that the origin, therefore, of the differential pensionable ages were indeed to correct factual inequalities, this factual inequality I mentioned, between men and women, and appear therefore to have been objectively justified under the Article 14 of the Convention. Now, what I saw about this application was that it actually goes into accordance with the general principles because of the historical discrimination we see between women and men in work. And this allows women to have certain benefits to stop in certain way the discrimination. Then it follows that the difference in pensionable ages continue to be justified until such time as social conditions has changed so that women were no longer substantially prejudiced because of a shorter working life. So what we're seeing here is that United Kingdom is also saying that even though this law is existed to protect women, this was in a completely different context. So when the United Kingdom starts seeing that this condition between women and men are going to be equal, they maybe could change the law because it is no longer needed. So now that we see the application that they gave to the law, we are going to jump into the conclusions. So, in conclusion, the court finds that this Social Security law, and in particular Article 4 and Article 7 of the Council Directive of United Kingdom, it did not violate the Article 14 of the Convention of the European Convention of Human Rights, and it was because this difference in pensionable ages was fundamented on a disadvantage in the economic field and the position of women in society. So it continued to be reasonable and objective to justify on this ground until such time as social and economic changes removed the need of a special treatment for women. So they are saying that until there's not condition of equality in society between men and women, this law should be still ruling in United Kingdom. And the respondent states decisions as to the precise timing and means of putting right the inequality were not so manifestly unreasonable as to exceed the wide margin of the appreciation allowed in such a field. So the decision to link the eligibility for REA to the pension system was reasonably and objectively justified, given that this benefit is indeed to compensate for reduced earnings and capacity during the person's working life. So, therefore, there is not a violation of the Article 14. And this is the case, which I think it was a really interesting case because we almost never question why this situation of pensionable age is different between women and men, and now we can see that it is because a historical background, and it actually protects the economical stability and position of women in society. So that's it. Thank you, and see you later.